following is a live copyrighted presentation. Ladies and gentlemen, it's time now for RadioLawTalk.com with your host, Frederick Penny, attorney at law. And now, RadioLawTalk.com.
Yep, that's what we're going to be talking about. Taylor Swift today. We've got a lot of fun topics, and oh my gosh, we've got our deodorant out. We've got clean clothes on. We got comfortable seats because we're going to be here, how long, Denise?
3 entire hours.
3 hours. We're going 3 hours today officially. From here on out, we are a 3-hour program. We have quit our Saturday jobs.
By the third hour, it's going to be a full-on cage match. You know,
I think after 2.5 hours, the listeners are going to go, do we still have to listen to those 4 people? I'm your host, Frederick Penny. We're hanging out here in the studios in our secret hiding place where lawyers hide out to do some radio law talk. And I have my great host here. Of course, the most important one to my right is Denise Dirks, who is a family law attorney in California. And to my left, Todd Cunin, who is, in my opinion, one of the best criminal law defense lawyers around, a former prosecutor for the district attorney's office, now has his own office. And oh my gosh, guess what? He and Denise are now sharing an office together, and who knows how that's going to work. After about 6 months, I think you guys will be fighting each other across the table. But you guys moved in the same office.
Complementary practices.
That's
Yes.
exactly right. So that's
Very true.
Let's see how that works out. Chris and I are far away, but Chris Rodriguez to our far left and front, closest to Cal. He is a corporate lawyer. You do all types of stuff, but you do employment law. He's a big partner at a big firm, and let me tell you right now, he went to Harvard, as we've talked before, and we love talking about Harvard. But
Fred loves talking about that. Yeah.
Yeah, Harvard is where Chris Rodriguez hails from, and there's different things that happen at Harvard that we won't talk about this hour, but maybe the next hour. But here's another exciting thing about today's first 3-hour program, and that is we have our first official research person that handled the research for us. What we've done is we've gone out to law schools throughout the western United States, and we have law clerks actually do the research for that week, and we love to mention them on the air and talk about it. His name's Michael Shear from Thomas Jefferson School of Law. Good job, Michael. We were able to review all your hard studying and your research and probably changed 90% of it. No, just tease. When we're law clerks, we used to go and turn in your paperwork. I remember working at a Bay Area firm, and my first big project was a huge case, and they wanted me to do analysis on it. And I remember the name of the lawyer to this day. This was 28 years ago. I remember turning it in and him reading it. And I came back about an hour later, and this is no lie. Literally, I looked over it, and it was sitting in the garbage. And I walked up and I go, well, what happened? He goes, we don't need that. And he completely rewrote all his arguments. Everything that I argued, he threw out. So
that's what you don't realize when you're a young lawyer or a summer associate or something like that starting out. Many of the assignments that you get are actually just because the person that was giving you the assignment couldn't think of anything, so they just made something up, and they don't care whether you do it or not. It's not going to be used for anything that's real world. They just want to see your work and make sure that they want you to come back on the second day. So while you better do a good job at it, probably doesn't matter that much.
That's exactly right. And have you guys done that before? Has it ever happened?
Yeah. I did my first motion for not summary judgment, motion to compel, and it was 60 pages long. Needless to say, most of it got cut.
You mean the judge is going to... I know the judges will sit there and read all 60 pages, right?
Absolutely. That happened to me. The first law clerk position I had was working for a DA's office. And I show up there, and it was a smaller county, so I was working with the assistant district attorney who was prosecuting a guy for murder. And they were seeking the death penalty. And so show up and he gives me some research or some motion in limine to research that they were going to go ahead and put in the ultimate motion. And I didn't really think much of it, but I did a good job. And that was his way of testing, just to see if I could research and write and not be asking him a ton of questions and pestering him, making him actually have to do more work. So I did that, and I passed his little test and then was assigned a lot. But an interesting thing about law clerks, okay, from a labor and employment standpoint, there were some law clerks went ahead and brought a lawsuit claiming that, well, you know what, I'm an employee. You guys are directing my efforts. I'm doing work. I'm doing all of this, and so I should be paid at least minimum wage. And I believe there's an opinion out there where a labor department said, well, law clerks, if they are given too much autonomy, could be deemed to be employees. So in order for them to not be employees, they still have to be partially a burden to the place where they're working. They can't be purely beneficial. They have to actually take up some time of the supervisors. So in order for law clerks to maintain their non-employee status, there are some labor code or labor department officials that believe that the law clerk has to be not too productive, has to be burdensome.
Well, I'll tell you, back, again, this is 27, 28 years ago now. It was a little bit different, too, then. I remember coming in as a law clerk in the mega firm in the Bay Area, and I remember walking in and eating my lunch with the staff in this staff area. And I got this weird look. They're all staring at me. I wish you could see this on, we're live on YouTube, staring at me, giving me this weird look. And then one of the secretaries walked up and whispered to me, said, "You don't belong here." I said, "What? I don't belong here." She goes, "The lawyers go in the really fancy conference room and eat." And sure enough, so I stepped out, and actually I felt more comfortable around the staff than I did the lawyers. Walk in there, and there's the lawyer. There's all the booze and all the, all the really nice stuff was sitting right there for the lawyers, and they were in there quietly, very stoically eating. And I was like, this is not fun.
It's changed a lot. When I started practicing, at a big firm, the partners would only talk to other partners. So if they wanted their assistant to do something, they would tell, the sixth-year associate who only talked to people in their sixth, fifth, and fourth years would then talk to the first-year associate and the first-year associate. It was all very regimented, and just like you said, it makes you feel extremely uncomfortable. That's not how it is now as much, but a lot of these old school lawyers, operated that way.
Well, and I got to tell you, I hear a story like that, and my heart immediately goes out to Jennifer Lopez.
J-Lo.
And I'll tell you why. Because Jennifer Lopez and other celebrities have repeatedly been just harangued in the press because they don't talk to their underlings. They only talk to the important people. They don't talk to staff. And everybody says, "Oh, you're a prima donna because you're a celebrity." And now we're finding out that happens in law firms, where the partners only talk to other partners and don't talk to the underlings. And my heart goes out to the Jennifer Lopezes now. I have a newfound respect for them.
I know you do. Go.
Well, just because Jennifer Lopez is a jerk, and lawyers, I still think she's a jerk, and I still think a lot of these lawyers that act that way are jerks. The big firm lawyers that act that way should be called out as jerks. They just don't have as much of a limelight on them.
Chris. I am under the impression and hope that Jennifer Lopez is listening. And so I am going to say, Jennifer Lopez, my heart goes out to you. And I know you can't see me unless you're following us on YouTube, but call me. So, when you're not hanging out with, who's Alex Rodriguez, former home run hitter for the Yankees, who's her now beau. But, if you ever want to have lunch, I'm your guy.
Just don't ask Taylor Swift, because we will get to the Taylor Swift thing, but we diverged a little bit from the topic because we got 30 seconds left. But go ahead.
Todd will ask Taylor Swift out next hour.
I will. Taylor, if you're listening, if Jennifer Lopez does not step up to the plate, and I have it on good authority she won't, hey, I could be trouble.
And
all right,
keep your hands to yourself.
Yes.
With that, we got to leave this segment. We'll be back to really talk about Taylor Swift, what's going on, and the legal issues.
And Todd's Match.com profile.
Absolutely.
Be back.
Radio Law Talk. I like
From north of the 49th parallel or north of the border, here's another Made in Canada hit.
That's right, mainstream Canada all over the world. You're listening to RadioLawTalk.com. Now back to the show. Here's Fred.
Thank you, Cal. That was a great introduction. Just remember a couple of important things. First of all, when you're tired of politics radio, you land right here at Radio Law Talk. We talk about the law and how it applies in your life. But an important thing to remember is, and this is the lawyer disclaiming, which is a shocker, go seek a lawyer with your own personal legal need. Because guess what? We have to say that because lawyers need money.
Wait, we have disclaimers here?
Yes, we do. We have a disclaimer, and that disclaimer goes on and says, because we're talking general law, and your specific case might need a little more attention than just Chris Rodriguez mentioning about putting, like newspaper things in the back of trunks.
Or stuff.
Yeah, well, Todd was saying during the break that it was so great to have hundreds of thousands of clients out there listening to us. And we had to say, no, Todd, they're not our clients. We have to make that very clear.
Right.
You're not our clients out there. We're just here to entertain you, maybe get you to think about things in a little bit different way. And if, like you said, Fred, if you have a legal need, you actually have to talk to somebody who is your lawyer.
I was thinking big and prospectively and optimistically that I should have said hundreds of thousands of potential clients.
Here's the deal. Here's the thing that's the best part about it is the off-air stuff is so much better than what we do on air. We go off air, and the first thing Todd says is, let's open our blinds like they do in the Today Show. Or was that you, Chris?
That was Chris.
Chris had said, maybe all the law students around the country could stand out there and hold their little signs like we're really popular or something, like UCLA law student or Brigham Young University law student, because we got some of those guys going to be working on our cases. And then Todd said the best one. What is it?
Is somebody signs out there and says a sign says, "We'll research for food."
That's the way it was when we were in law.
That's
when we
right.
were practicing law, not practicing law, but beginning of practicing law or in law school. Oh my gosh, was that the time to make sure we had food on the table?
Oh, I went to law school down in San Diego, and I had to, to Michael Scheer, who did our research, from an alumni of a school that's about 15, 20 minutes south of you. Good job, and you'll know which one that is. But I couldn't even go to the beach for the first 2 years because I knew if I went to the beach, I would not study. Studying was hard enough as it was. But, law school, you really had to get knuckled down and had to focus.
Yeah, that's why you don't go to law school in Southern California. You go in North Dakota somewhere.
Hey, if you guys want to call in at 855-LAW-RADIO. That's 529-7234. Or tweet us at Radio Law Talk.
That's why we have Denise, because us guys, we just sit here and shoot the bull the whole time and not talk law. Tell us about Taylor Swift. What's going on? Denise and Todd have been bantering about it. What's going on?
Taylor Swift, oh my gosh. I have to amend something I said the last segment. Taylor Swift's top of my list. Jennifer Lopez, sorry, you didn't call me over the break, so it's Taylor Swift now. But Taylor Swift was, for those that don't know, is in the middle of a lawsuit. She was sued by a radio DJ who lost his job after going to a meet and greet at a concert in Denver, at which time Miss Swift alleges that during the photo op, he reached down with his right hand and grabbed her left cheek.
So much like an angel when he smiles at you.
Where are we going with this?
I don't know. Cal's back there playing.
That was very.
There's a song called "I Knew You Were Trouble," and this is part of it. But anyway,
There we go.
this was the lead up. But I liked the line "I knew you were trouble." I just thought it was kind of.
Cal's back there playing. Here it comes. Here it comes, Todd.
Cause I knew you were trouble when you walked in. So shame on me now, flew me to
Right on.
Nothing better than a slipped sound cue, Todd.
Boy, seamless.
The part that you played, it sounded to me like it was Jaws, music from Jaws. Like, here comes the hand toward her buttock.
In the video, she's at like Burning Man or something, and she wakes up and there's nobody
Trouble.
around but her. So trouble. Yeah.
If we have to start singing this, we're in trouble.
trouble.
As a side note, I want to have this song playing over the loudspeaker every time a young man comes over to pick up my daughter for a date. Yes. I'll just go ahead and play this in the background. You are trouble, 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 and I have no problem going back to prison.
Yeah, there's a country song to that effect, right?
So what was Taylor Swift sued?
Taylor
for?
Swift was sued by this DJ for intentional interference with contract, and not just her. She was sued. Her mom was sued, and their business manager was sued, as well as the radio station. What they're alleging happened was that,
Which, by the way, I'm going to interrupt, is owned by CNN, the radio station.
I believe so, yes.
Yeah. Mm-hmm.
And so what happened was after it was a meet and greet and turned into a meet, greet, and grab. And after the grab, Taylor Swift left, went back and told her mom in the dressing room. This is all just before the concert starts. And she says, this guy just grabbed my butt in there. And so the mom went and talked to the business manager who called the radio station. They talked to security, never reported it to the police. Security went to the guy as he was waiting in the front row to see the show and said, you're out of here. And he objected, why, what happened, and they told him what he was accused of. He leaves. And but when Mom called the radio station, she said, I hope you'll do the right thing. I want this guy fired. And they fired him.
So this is what they're alleging. I mean, this is what they're alleging.
Well, yes, this is what they're alleging.
But I think
happened.
that was an admission
Yes,
by Mother.
and in the depositions and everything that came out, and in the motions for summary judgment, these were the facts that were alleged. And she did say, I want him fired, and he was fired. He had a contract for $150,000 a year for 2 years. The station had an option for the third. He was terminated, and so he files a lawsuit alleging interference with contract and interference with future economic prosperity.
And we will talk later, or Chris, what a motion for summary judgment is, because we're throwing out legal terms here. Some people are going, what's a motion for summary judgment?
Yeah, well, let's talk real quick before the break about what those claims are. So basically, if I know that you have a contract with somebody, Fred, and I go to the person that you're contracting with, and I do something that causes that person to breach their contract with you, that's illegal in almost every state.
Or revoke the contract. It doesn't have to be a breach necessarily.
Right. Or do something to cause you harm in that contractual relationship.
Exactly.
We're going to continue to talk more about motion for summary judgment and Taylor Swift right after this.
Thanks for listening to RadioLawTalk.com. We think you'll find it's a treasure. Now back to the show.
You know, I've been doing this for a while when I'm eating literally about 10 seconds before the show starts. I mean, before when we first started this, 4 months ago, we be all ready and completely ready 45 minutes before, arms folded. Now it's like, all right, we're starting in 10 seconds. Let me just finish this up here.
You are a true pro.
No, I'm not. I just think, and this is just more fun just to roll with it. Todd, keep
more
going.
fun than we ought to be allowed to have. So, getting back to Miss Swift, we should hyphenate that, Miss Cunin Swift. But anyway, so
we're going to get a call from their legal team.
Oh, and let me tell you, they have an aggressive legal team. I'll get to that in a little bit. But she has a lot of legal representatives looking out for her and protection of her materials.
Maybe she needs Radio Law Talk hosts to represent her.
In fact, this just in, I didn't think you could pull this off that quickly. You have a restraining order against you that was just issued by the Superior Court on a Saturday. You are not to come within 300 yards of Taylor Swift.
I believe if you read the fine print, that is just a reminder of the restraining order that was already in existence. So the DJ sues Taylor Swift for $3 million.
Disclaimer, that was just a joke.
Yes, that was just a Radio Law Talk. I've got attorneys here that are all going to drop me as a client here in a drop of a hat sitting in the room with me. So he sues her for $3 million.
Right.
Well, she files a countersuit. Mind you, she did not report this to the police. She didn't do anything, but files in a countersuit sexual assault, and she is only claiming a whopping $1 in
damages.
In damages, but it's
nominal damages,
ceremonial or symbolic damages, and that's what she's seeking. But she's standing up for women everywhere that have the right to, be able to dress nicely and shouldn't be subject to the groping hands of an individual. His wife was standing right next to him.
It was his girlfriend.
It was a significant other.
Yeah.
Was standing on the other side of Taylor Swift. I don't think for a minute that maybe alcohol was involved, but that
Yeah, I think it said what might have been.
that could have been. And so we've got this issue here, and the plaintiff or the defense filed what's called a summary judgment motion back in May.
There were two filed. One each. The plaintiff and the defendant filed motion for summary judgment. So they had competing motions.
So, what, Chris? Explain what a summary motion is, Chris.
Okay, so when you file a lawsuit, there are a number of different junctures in the case where the legal team that's defending against that claim can get rid of the claim. So you can file, as soon as the complaint's filed, you can file a motion, which would be called a motion to dismiss or a demurrer in California, and say, even if you accept everything that they said in this complaint as true, they still lose. And so you can try and get rid of that claim right at the beginning of the case.
The judge decides that, not
The
a jury.
judge. The judge decides that.
It's a matter of law.
That's correct. And then if you get past that demurrer stage, discovery happens, and people go and they take depositions and they get to look at all the evidence and they exchange documents and they grill people in conference rooms at depositions. And then after all the evidence is gathered, the defense team can make a motion for summary judgment, and they can say, we have looked at all the evidence and the evidence does not support their claim, so you should throw the case out on that basis. That's called a motion for summary judgment.
This is a federal case, so it's pretty standardized throughout the United States. The motion for summary judgment literally means that there's no dispute as to any material fact, and the judge has to find as a matter of law in favor or against the party that had made the request.
Now, another thing that's important to note is you mentioned the word discovery. People are like, what does that mean? That means you go through depositions, they're written interrogatories or questions back and forth that they got to sign under oath or declaration. So the evidence, they've got to produce documents, they got to do what's called request for admissions, they got to admit or deny stuff. So there's all this evidence that's rolling in. By the way, that's where the lawyers make all their money, because there's a lot of work there. And then at that point is when they say, okay, after all this evidence, before it goes to the jury, we're going to bring a motion for summary judgment.
Yeah, what's really important in this case is that David Mueller, that is the plaintiff in this case, the former disc jockey and radio host, what he did was he destroyed evidence. He had a computer and he had a telephone, and he had recorded the conversation between him and his boss that fired him. And he ultimately, that evidence got destroyed. He claimed it was destroyed by water getting on him. And he got sanctioned, and he got a big, large sanction against him for destroying the laptop and the phone.
He did disclose, what he did was he had that. It was the raw data that got destroyed. He did pare it down and edit some selective pieces of that conversation. That was discovered, but they wanted to get the whole conversation to have context, and that was what got destroyed. He says he spilled his coffee on his laptop, and then the data storage devices got messed up, and so all of that was lost. And you're right, the court says, well, I guess you could make the argument that it was by mistake, and the only way that we could really exclude all of the evidence is to find that there was a bad faith destruction of evidence. If we credit him with his story, we can't find that it was bad faith, but it certainly wasn't optimal.
Yeah, so this is, I think, a helpful point for our listeners. To the extent anybody out there is in litigation, you have an obligation to keep in good condition all of the evidence that might be relevant to that, even if it's harmful to you. And so a lot of litigants, when they realize they're going to be in litigation, they go and they delete emails that they think are going to be harmful. And that is one of the worst things you can do if you get caught. There are even things called terminating sanctions, and I'm sure that Mr. Mueller was very close to having that happen to him here. If a judge thinks that you destroyed evidence that could be helpful to the other side, they can just say, I am issuing the sanction of you lose. So thank you for playing. But it's just as if we went through a jury trial and the jury found against you, you have lost the case because you destroyed evidence.
And social media is evidence, people. Do not forget that. Social media, your social media accounts are evidence. Do not delete them.
Here's the interesting thing. I'm sure all of you say the same thing to your clients. Roll in, sign up the case, get off social media.
That's right.
I mean, I have won more cases or gotten bigger settlements on more cases because of social media than you could ever think. And it's just important to note that you can't get rid of it. And the funny thing you mentioned, Chris, you said, if you delete it, you may get in trouble. Let me tell you, those computer guys, it's never deleted. I mean, they find ways to resurrect it.
We had a case one time where we obtained terminating sanctions. Our forensic analyst was able to determine that the opposing party ran a program on his computer, I kid you not, called Evidence Eliminator. That was the name of the program that he ran. I mean, that's pretty good. Those are good facts right there when your opponent runs Evidence Eliminator.
And you sit there and tell the jury, they ran Evidence Eliminator. We have no more facts or evidence to discuss with you. To the jury. Go ahead.
Todd, what does Taylor Swift have to prove in her case against David Mueller?
Well, so Swift is alleging against Mueller that she was sexually assaulted. And if the case were in California, for example, and this is in Denver, but the standard is pretty much the same. It is sexual assault. California can be either a misdemeanor or a felony. On these facts, it would probably be alleged as a misdemeanor. And basically, it is without consent, an individual intentionally touching an intimate part as defined of another person's body, and the places are the genitals, the breasts, or the buttocks. And so this allegation was that he reached over, put his hand up under her skirt, and grabbed her left cheek, I think it was, and that would fall right within the status of that assault. Now, mind you, this is a civil case. It's not a criminal case. And the key distinction there is, in California, a criminal, even a misdemeanor criminal violation of that code would require registration as a sex offender.
Yeah, not good. And what's interesting is, and you might want to talk about this when we come back from the break, why didn't the district attorney pursue an action here for criminal
because
issues?
It wasn't reported.
She did not report it.
And it's basically a he said, she said. And David's girlfriend testified that she didn't see anything. So there's really no witness. The best piece of evidence they have, besides testimony, is the picture. There is a picture where his hand does appear to be close to that vicinity. It doesn't look like it's there, but it's close.
But the question is, and the photo, I've seen the photo, I don't think it shows much, frankly, because if you stand with somebody and you take a picture, sometimes your hand might be around that area. If it's over the skirt, I think that might be viewed as more legitimate and not intentional. If it's under the skirt, we got a problem.
But
right?
guess what? That's just one picture. What happened before and after that picture? That's the issue.
We talked about this the other day with regard to police videos. Remember, there was that one incident where it looked like the cop was shooting somebody that was unarmed, but the other video showed that the guy was shooting behind. We only have, in this instance,
DJ
one
should
video.
wear body cams.
One-dimensional.
Yep. All right, we'll be right back. Talk more about Taylor Swift.
This is no fun.
Thanks for turning us on. This is RadioLawTalk.com.
I can't walk out.
Remember, when you're tired of radio politics, we're here talking about non-political things. Taylor Swift.
Taylor Swift and her meatloaf.
Okay.
Wasn't that Meatloaf that was just playing?
No, that was Elvis Presley.
Oh, well, forget. I just aged myself there. Sorry. Can we start over?
For the record, Chris was talking about the singer Meatloaf.
Elvis, Meatloaf. Yeah, I can see the confusion.
Hey, Chris, turn about being fair play. It's amazing how quickly the Swift legal team works. I'm looking at a notification from the court ordering Chris Rodriguez to stay 300 yards away from Taylor Swift and to refrain from referring to
Elvis as
Meatloaf or any inferences that might be drawn from that. So, hey, good job. We are brothers in restraining orders. Booyah.
Yeah, and for those of you watching on YouTube, when this chair is empty for the next couple of hours, you'll know why.
Sheriff walking through the door. But they don't know where our studio is, so they can't find you.
No, they're just looking for the throng of law students outside and a location holding up signs We'll research for food. That's got to be the place.
That's the place.
Our audience demands that the hosts of this show know the difference between Meatloaf and Elvis.
Well, I'm going to give this to you. You're so young. I think you're the youngest one in this office here. You don't even know what Elvis is, I don't think.
It's not that hard.
Oh, okay.
To be the youngest.
I did mention the other day to my kids, no lie, I said this. Yeah, the Rat Pack, and they looked at me with these glassed eyes. The what pack? The Rat Pack.
Were those the guys that were hunting down the mutant Ninja Turtles?
That's exactly right. So, look, it tells you if you're a big superstar, give it 30, 40 years. After you're gone, nobody really cares and nobody knows.
So we were talking about summary judgment before the break and various things. So there were summary judgment motions brought by both sides in the Taylor Swift case, and the court issued a ruling in May. That's before the trial started a couple weeks ago. And in it, the court denied most, if not the majority, of the summary judgment motions brought by both sides, but did grant one of the summary judgment motions brought by the Swift team seeking dismissal of the disc jockey plaintiff's claim, and that was the claims for defamation and slander, and the basis of the motion was that he missed the statute of limitations when he filed. And the court granted that, and that is why nobody in the Swift team, Taylor Swift, her mother, their business manager, is facing any liability for slander here because that motion was punted. On the other motion, with regard to whether or not Swift herself was liable for making any report, whether it went to her mother and ultimately got back to the radio station, the court had some interesting language in the summary judgment motion decision that the court wrote with regard to how close of an issue it was whether Swift should be liable. And the court said, and I'm quoting here, "To be clear, the court views this as a close question. There would appear to be nothing improper about Swift or any other person making an honest report to an entity with which she does business that one of its employees assaulted or harassed her. Indeed, in the undersigned's view, the policy of the law should encourage reporting of actual assaults, not attach liability to it." And so from just her perspective, not her mom, not her business manager, but from her perspective, I think that was a big hint to her and also a hint to the plaintiff that the court is really looking at your claims against her with a skeptical eye.
Yeah, because the reporting the actual act is different, though, than making a request for him to be fired.
Absolutely. And there's no evidence that Swift herself made that request. In fact, all the evidence in the summary judgment motion, everything, attribute those requests to her mom and or business manager. And the judge seems to be protecting Swift's right to make an allegation if she was indeed a victim of sexual assault. And quite frankly, I think that's the way it should be.
I agree.
You don't want to have people being afraid of making an honest report out of fear that somebody's going to come back and try to sue them for $3 million.
That's correct. But what the court was very clear about is if it could be proven at the trial that Taylor Swift knew that there was no butt grabbing and she was making it all up and she put that out there, then there could be liability. So he was talking about a bona fide report. It doesn't have to be a true doesn't have to be what actually happened, but if that person believed in her heart that that's what happened and she reported it, there should not be any liability attached to that.
That's right. You don't want to quelch the reporting aspect because it's already hard enough to report sexual assaults. Victims often don't because they don't want to be, questioned and challenged and stigmatized.
Or the publicity, especially in Taylor Swift's case. When this case first popped up, that's the first thing I thought. Why would she want to do this? Well, it's because she got sued and she's just cross-complaining. I'll tell you right now. She said, I bet afterwards, look, I'm just going to roll it under the rug and just move on. And this guy came after her and her mom and her manager. And so why not?
And let me tell you something about reporting and why would she report? Why would she not? I mean, she did not report this to the police, and she's only bringing it up here. And some people might ask the question, well, she's not acting like somebody who is the victim of sexual assault. And here's something that I learned when I was a prosecutor, because I prosecuted the sexual assault crimes in the jurisdiction I was in for about 4 years. And this is something that I learned about victims of sexual assault. There are as many responses to sexual assault or types of responses as there are victims of sexual assault. In my opinion, there is no generally accepted normal way for a person to respond because it is specific to each individual. There are some that when this happens will go immediately to the police and stand up and say, this person did this. And then there are others that will withdraw to a shell and withdraw from everybody and sadly enough pray that they were never born. And then there's every response between those two. There is no normally accepted way to respond.
And there are others that don't want to be viewed as a victim. And that may be the case here for Taylor Swift. Now, does the plaintiff have a good case against the mother and the business manager? Yes.
Well, I'll tell you, when you look at tortious interference with a contract, especially in light of the way that Chris explained it, he has a contract with his radio station. Mr. Mueller does. The contract is for $300,000 over 2 years. He expected to be able to continue in his employ, and she came in. Miss Swift's mother came in, and the evidence is that she demanded that they, quote, do the right thing, and the implication that I believe she admitted to was she expected him to be fired.
That's
and
right.
she actively sought that.
But there's something else we have to take into account here. There has to be, just because I know that the DJ has a contract with the radio station, and I act intending to interfere with that, you also have to take into account the mother's First Amendment rights, because you can say you have the right to speak under the First Amendment of the Constitution. And so that is, I think, what the judge was even referencing in his summary judgment order. You cannot quench somebody's right to speak out when they have been wronged or they think something is happening. So it's an interesting dynamic there, whether there could be liability for somebody standing up for themselves or their daughter and speaking the truth.
Looking here at the summary judgment motion that went over the elements of interference, first thing, knowledge of the contract, okay? The second was whether or not the actions were improper and intentional. Well, there's no question it was intentional that she meant to do it. But then they got to the issue of improper. Was it improper for her to do, the mom to do what she did? That's where we have the language from the court saying, I don't think it's improper to report sexual misconduct.
Right.
It's not. The other thing is, the guy had a morality clause in his contract.
Exactly. That's what I was saying. He didn't sue his employer, did he, for wrongful termination?
So, if they did not, if they were justified in terminating him because of the morality clause, he's kind of up a creek.
As they always say, the jury's still out. This is still ongoing. We'll talk about it another time. I want to say this. I'm excited to say this ends our first hour. We will see you at hour number 2 and talk about Bitcoin.
The following is a live copyrighted presentation. Ladies and gentlemen, it's time now for RadioLawTalk.com with your host, Frederick Penny, attorney at law. And now, RadioLawTalk.com.
We are on hour 2 of RadioLawTalk.com. Excited to be here for our second hour, first time ever, doing a 3-hour show. And we'll be doing this hopefully forever until we're in the grave. I'm here with my hosts again, Denise Dirks to my right, my favorite host, Denise Dirks, who is a family law lawyer, and to my left, I'm not going to say is my second favorite, but it is Todd Cunin, a criminal lawyer, and Chris Rodriguez, my longtime friend that I've known for quite some time.
But least favorite co-host.
Depends what day it is. But Chris is an employment law corporate lawyer at a big national law firm. But anyway, we're excited to be here. And remember, it's important to seek your own attorney for legal advice. We're just talking about general law topics. You can call us at 1-855-LAW-RADIO, or Denise, tweet us how?
At Radio Law Talk. And we love to hear from you, and chime in whenever you want to.
And we're going to talk a little bit about Bitcoin this time. And let me tell you, we have a lot of topics that we talk about. We always want to talk about the latest topics. And we all have our specialties. Let me back up. We all know certain areas of law. As weird as it sounds, there's words that we can't use as lawyers called specialties and stuff like that. But this is all we do is certain types of law. But we study other areas of law. But this Bitcoin thing is kind of the hot topic. We've got to talk about the law and the SEC issues with Bitcoin, and that's what we're going to talk about. And everyone's like, and it's funny because what those of you who don't know what's going on behind the scenes, everyone's looking at each other going, do we have to talk about Bitcoin? That's why I went to law school, because we don't like this computer stuff or accounting stuff. So, but we're going to talk about Bitcoin. What is Bitcoin? Bitcoin started. Go ahead.
I was going to say, that's what I want to know. What is Bitcoin?
I want to know what SEC is.
Did I say SEC?
Yes.
Yeah. Okay. Well, I mean, close enough. The Securities and
It's the
Exchange
Southeast
Commission.
Conference. It's like one of the best football conferences in college football.
It is the Securities and Exchange
that
Commission.
SEC.
Yeah.
Thank you
There
for
you go.
that clarification.
Well, I thought you clarified. I thought we're lawyers. We know what SEC is, but everybody else thinks it's a football area, what do you call it? Conference.
It's a conference.
Football conference. Who's in that conference, by the way?
Let's see. Tennessee, Florida,
Oklahoma? No?
Alabama, Southern, right?
Mississippi State.
It is regarded by
Auburn.
by many people as the most powerful conference. I think they claim to have more NFL players that are alumni of the Southeast Conference.
Well, I think that rolls right into the SEC, Securities and Exchange Commission, is probably one of the most powerful government agencies that we have. That's for sure, because they regulate a lot of the businesses, a lot of stuff to do with the New York Stock Exchange, and they're going to try to figure out if they can regulate Bitcoin. So let's go over very briefly what Bitcoin is. Bitcoin started in 2009. And what it basically is when we have money, there's always a middle person or middle company when it comes to exchanging money. And who's that person? The bank. So the bank has buildings, employees, all types of overhead that they have to cover in order to take this money and exchange it between two parties. Todd and I are going to, exchange money I'm going to buy his toaster at his house. It's probably broken. And so
it is.
in order to do that, the banks have to go to the bank, get my money, give him the money, and then you got all the regulations about the government overseeing how money is distributed, how much is made.
How much money the bank has to actually have in its vault or in its deposit accounts in order to do X, Y, and Z. And
exactly. And
Jimmy Stewart, but the money's not here at the bank. It's in Walter's house. It's in Jimmy's house. It's over there. That's what we're doing here. Come on.
Oh, we got Jimmy Stewart in the studio, but here's the deal.
Show me the money.
Exactly.
There you go.
I didn't even know the difference between Elvis and Meatloaf. I don't even know who Jimmy Stewart is. But
oh my gosh.
That's beside the point. I actually know more about Bitcoin than I do about Jimmy
Well,
Stewart.
here we go. Let's continue on the Bitcoin. So what happens is you take the middle person out. And Bitcoin is people exchanging money. It's called a Bitcoin, back and forth in order to buy or purchase something or sell something.
And they buy the coin with dollars or whatever the currency is where they're buying the coin.
Or they can receive that by what's called mining. And what happens is these banks get paid money, correct? So these miners are people that are basically computer people, understand how to organize this medium of Bitcoins, and it gets into detail about the bit miners and how they basically keep everything organized, and they get paid for that, and that's how they make money. They get paid to kind of keep an organization. They have these pools, and they figure out ways to keep it organized. Who's buying what and paying for what?
It's basically a ledger, a public ledger that's called a blockchain. So the miners are the ones that are keeping track of this ledger, and they are paid to do that.
Cal's in there. I gotta say, Cal is putting a gun to his head, pretending he's shooting himself because this is such a boring topic. And I agree it is boring, but we got to get into why this is important to talk about.
Well, I agree with Cal. As I'm sitting here, I'm not a sci-fi guy, and my son is a huge sci-fi guy, and he is telling me about the movies and how the dragon comes out of here, and then there's these bit miners that do this. I have the same feeling. I honestly could care less about any of this. As a consumer, all you care about is that there's a different way that you can pay for things, right? I mean, like Apple Wallet or some. It's just basically an app that you can pay for things with, right?
It's the value of the Bitcoin. That's where the big payday is.
Absolutely.
Right, Todd?
That's why it's important to talk about this, because it is absolutely taking off. And the issue is, can they regulate this business under the SEC, Securities and Exchange Commission, and the government tell them what they can and can't do? Because the government is kind of at first lost. Like, what is this? They couldn't figure out, do I categorize it as currency? Is it software? Is it a security? They can't figure that out, but they finally figured it out. But go ahead, tell about how Bitcoin has gone up in value, Todd.
Because if it wasn't worth anything, the SEC wouldn't care. And when you look at Bitcoin, all right, back in 2013, one Bitcoin wasn't worth a whole lot. In 2016, about a year ago, the exchange rate for one Bitcoin was somewhere between $200–300. Today, a year later, one Bitcoin, $3,855, almost $4,000. It's gone up from $400 to $4,000 here, and that's why the SEC is looking at it going, well, this is going to turn into a huge investment tool. There are people that already trade on the currency market, buying up yen, waiting for the dollar to get strong or up and down, and rubles and all over the place. And they know that Bitcoin is going to enter into this fray. And Bitcoin isn't traded on the NASDAQ. It's not traded in the New York Stock Exchange. It's kind of unregulated, or definitely unregulated by the SEC. And they're concerned that there could be open for fraud. They want to be able to get their tax money out of it.
It's amazing that that it's basically international currency. You can buy it with any type of currency, and the Bitcoin itself is not subject to market fluctuation as local currencies could be. So this is more of a global type of currency.
I'm taking a picture.
And the number of places that accept Bitcoin. Now, this is amazing. Back in Sacramento Kings, back in 2014.
Cal, you got to sit. Sorry, I'm going to interrupt it. Sit like you were before. Don't sit. Use like this. I'm tweeting that out. He is absolutely dying back there. He's going, this show is going to pot because nobody's interested in this. We got 15 seconds left. It doesn't matter. He's happy.
Can we talk about Taylor Swift or marijuana or something?
We're going to talk about this very briefly at the next, after the break, and then we'll get out of it.
Hey, tweet us, radiolawtalk.com.
And we thank you for listening to All About Bitcoins on Radio Law Talk.
The money.
You're listening to RadioLawTalk.com, and we thank you.
So Bitcoin, there's the Howey test to determine whether or not Bitcoin can be regulated by the SEC, the Securities and Exchange Commission. And this Howey test, and I can get into details on that, but you know what, that is so boring, I'm not going to get into it. And we were talking on the break. This is our real life.
It is.
The Taylor Swift fun stuff we're talking about, laughing and exciting. people who are out there thinking of going to law school, being lawyers, the vast majority of your life is drab. Research, writing motions. You do argue before the court, but it's a lot of work, and it's this type of stuff.
You know, we look over at Cal here, and he's doing the poke my eyes out with the rusty nail look here. And I want to say, before we get onto that, the music that we play going in and out of breaks, all this stuff, it comes from Cal's personal iPod playlist. So this is stuff that he listens to relax. So it's nice to know you've got that 70s vibe going on there, Cal.
Are you saying you don't like the Bee Gees or Meatloaf or Elvis?
I'm not saying any of that. I'm saying I like the variety.
Anyone that understands Bitcoin is not listening because of that music.
That's right. Well, maybe. I don't know. But this is the point that we were talking about over the break. Back in 1989, anybody who heard this thing called the Internet or America Online and all that would have taken the exact same view toward that as a lot of people take toward Bitcoin right now, which is, what the heck are you talking about? And yet, in its heyday back in the late 90s, early 2000s, a $1,000 investment in America Online back in 1991, 92 would be worth $1 million in 2000, 2001. In the early 2000s, people were like, what's this YouTube stuff? YouTube? What? I can post my video. Why would I want to post my own videos online? And now there are kids that are worth millions because they understood the value of being able to produce their own content. Facebook, what's this Facebook stuff? And then people got involved with Facebook are worth a lot. By the way, did you see the movie The Social Network? The Social Network went over the creation of Facebook, and there's this allegation Mark Zuckerberg was sued by these two twins, the Winklevoss twins.
Right.
Well, you know what the Winklevoss twins' next venture was after they struck out suing Zuckerberg and Facebook? Bitcoin. They started their own exchange. They got in. They are trying to make it in the Bitcoin arena. And there are a lot of companies, more than you would know, that accept Bitcoin as currency now.
Yeah, and it is growing like wildfire. And I know we have a lot of law students out there listening. And we were talking at the break. Everybody knows 100 employment lawyers. Everybody knows 100 criminal defense attorneys, divorce attorneys, probate attorneys. There are so many. You fall out of bed, you're likely to hit one of those guys, okay, or gals. But I know one lawyer who specializes in Bitcoin, and he is doing phenomenally well because he got into this area and he knows it. And all of these companies that you're talking about, the Sacramento Kings, all of these cutting edge companies that want to know what Bitcoin can do for their business and how it can increase their business, they go to this lawyer to advise them. So if you're sitting there in your room studying torts today and you're thinking about what you want to do after law school, I'm not saying necessarily it has to be Bitcoin, but there are these little pockets of law that if you become an expert in that, you've done well for yourself. So think about that.
Exactly.
You mentioned companies that take it. You mentioned the Sacramento Kings back in January of 2014. The Sacramento Kings became the first professional sports franchise in all of professional sports to accept Bitcoin as a form of currency that you could use. Not surprisingly, their owner, Vivek Ranadive, is responsible for digitizing Wall Street, so he was already in on it.
And airline, the computers for airline.
Absolutely.
Yeah. And interestingly, now we're sitting here in 2017. There's still not one ticket holder that's ever paid with Bitcoin, but they do accept it.
But they do accept it.
Yes.
They do. Maybe. I don't know. But here are other companies that accept it. Overstock.com, Expedia, Dell. Those are three big ones. Mozilla, Bloomberg, USAA, Dish, Intuit, Bing, PayPal, Reddit, 1-800-Flowers, Time Incorporated. Those are... WikiLeaks accepts their donations through Bitcoin. So does, there's one other charity.
Well, while you're looking for that, if you are out there listening and you're behind on your Dish Network payments and you want to buy yourself some time, when they call you to say, hey, your bill's past due, say, no, I paid in Bitcoin. Go look it up. And they'll get back to you in about 2 years when they figure out. You'll be solid for 2 years.
And at $3,800 for one Bitcoin, you could say, I paid with one Bitcoin. And if it's Dish, they said, well, that covers about half the month.
So what's going to be the impact of the SEC regulating Bitcoin.
So what's happening right now is they've agreed that it does meet the standard or the test under the Howey test, and they can, quote, regulate it. But what they're doing right now is we can regulate it, but we're going to hold off because they just quite frankly can't figure out, I think, how to regulate it.
Exactly.
How do you regulate that thing?
Exactly, and that's what your Dish representative will do whenever you tell them you paid in Bitcoin. They won't know what to do either. If the SEC doesn't know, neither will Dish.
You notice Rodriguez is always trying to figure out how to get out of things. That's his whole life is, what do we do to go around it?
Well, the Howey test is an interesting test. It actually is there to determine whether or not the item qualifies as a securities that can actually be regulated by the SEC. And there are three main elements to the Howey test. Investors investing money with a reasonable expectation of profit derived from the managerial efforts of others. And that's where they found that the Bitcoin is a security and can be regulated. And we're going to see more about this in the up and coming years, maybe months, because I do believe the SEC is going to try to crack this nut, if you will, and they're going to try to see how they can regulate and protect the public.
And I think you're right. And more important than the SEC regulating this Bitcoin is it's going to save Cal when we end this segment of Bitcoin from committing suicide, because I truly think he's on the border right now of just jumping off a cliff.
And whether or not we would be liable for continuing to use the word Bitcoin, knowing that Cal is on the edge. We're like that girl back east that got prosecuted and convicted for convincing her boyfriend to do stuff. Bitcoin, 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 as Cal turns more and more blue in the face.
We'll be right back. Cal can't wait to shut her down. We'll
Spice Girls.
Stay with us.
Spice Girls.
I'm still trying to figure out what it means to me, but I'm sure we'll all discuss it and get it straight. Coming up on RadioLawTalk.com, and we thank you for listening.
Radio Law Talk. I like
I like that show too. This is RadioLawTalk.com, and we thank you for turning us on.
I'm Frederick Penny with Denise Dirks, Todd Cunin, and Chris Rodriguez. Spice Girls, Mel B, Mel Bitcoin. Mel B, Bitcoin, Bitcoin, Bitcoin. I'm going to do subliminal messages throughout the rest of the show so we drive Cal Bitcoin crazy. And every time we talk, we mention the word Bitcoin in the sentence.
I am down Bitcoin with that.
How about you, Chris?
I'm not playing. I'm not playing. No.
Chicken.
Sorry. I don't like it. I don't like it.
Thanks, man.
I got your back, Cal.
Well, it's a little-known fact that we are here in 2017 AD, and the BC actually stands for Bitcoin.
That's exactly
Yes.
right.
Thank you,
Bitcoin.
Mr. Clavin.
Yeah, at least I could do it.
We're going to be talking in 2 years or 3 years from now going, that Bitcoin, all my friends are millionaires and billionaires because of Bitcoin, and we made fun of it. But that's right. Let's talk about the Spice Girls.
Yo, I'll tell you what I want, what I really, really want. So tell me what you want, what you really, really want. I'll tell you what I want, what I really, really want. So tell me what you want, what you really, really want. I wanna really, really, really wanna zig a zig.
If you want my future.
Mel B filed for divorce from her husband, Stephen Belafonte. And there's a lot of salacious allegations going on, and
That's a big word.
we don't really know why there are salacious allegations going on.
What's salacious?
Well, salacious means off color, for lack of a better description. The allegations are that the husband spent money on the nanny to help her get an abortion, and that they had a relationship. And the nanny has admitted to having a relationship with both Mel B and her husband.
Wait a minute. This is not more exciting than Bitcoin.
Well, hey, but you don't know the most salacious fact. Belafonte has alleged that the child that was aborted was actually Mel B was the father.
Okay. This is
We
really
have now gone off a
Okay,
cliff, and I
that's
took
funny.
it there, and I'm proud of it.
Well, the
Harvard boy.
irony of this is filed in California, and in California we have irreconcilable differences i.e., no fault. Nobody has to be at fault to get a divorce, and yet these allegations have sprung. So why are they being used? Why is all of this happening? It's because it's an allegation of a breach of fiduciary duty that Belafonte owed to Mel B, would be to describe or to disclose the money that he paid to this nanny if this actually occurred.
Okay, I just want to. Most people do understand it, but Todd and I don't. Who the heck is Mel B? Explain who Mel B and the Spice Girls are.
Love to.
Come on.
Mel B is, she was Scary Spice. And the Spice Girls was a girl group that was very popular in the
early 90s. Yes.
And my daughter loved them. She dressed up as the little one, the baby Spice, and she was out for Halloween, and all of her little girls would come over and they'd all be dressed up as the Spice Girls. And they had really good music, actually.
Yeah.
But these
Show me the money.
Wait, her name is Mel B?
Yes.
I thought it was Melb.
No, it's Mel B. And she actually sits as a judge in today's world on America's Got Talent. So she is very, prominent. And these kind of allegations could, potentially harm her reputation. But they could also potentially harm the nanny's reputation as well. So there's some thought that the nanny may be getting ready to file a defamation suit against Mel B.
So, okay, let me make sure I got this clear, because this is very important. More important than Bitcoin, because I can make money on this and not on Bitcoin. So there's an allegation that he's giving away the community money or community property to the nanny.
Correct.
And how much? Does it say, or doesn't it?
Darn close to 300,000 pounds. Remember, these two, they're from England, but they live in the United States. So they had to file for divorce in the United States because they're actually domiciled.
So how
in
many
the United
Bitcoins
States.
is 300,000?
300,000 pounds, I don't know, but I know that it's a lot of money.
About 100 Bitcoin, I think.
You know what's interesting? What's interesting here is that Mel B is a judge for America's Got Talent, right?
Correct.
Do you know who else is a judge for America's Got Talent? Howie Mandel. What was the name of the test for Bitcoin for the SEC?
Howie
the
test.
Howie test. It all gets back to Bitcoin, Cal.
Cal's over there having fun with all the little...
Oh, listen, an angel just got... It's Bitcoin.
Cal is fielding calls furiously right now from sponsors that are pulling out.
That's exactly right. Go ahead, Denise. Keep talking about the important things.
So,
Mel B.
Mel B's husband, he filed for spousal support, and he got a spousal support order of $40,000 a month, which is a lot of pocket change. And he is a producer as well, so he does make his own income. So it does show kind of there's a disparity between the two parties and their earnings, for sure. They did not have a prenuptial agreement, and so there's a lot of money at stake. And if Mel B can show and prove that her husband breached his fiduciary duty to disclose to her the payments to the nanny, then she could get potentially that money and maybe more, the cost of trying to get that money back as in terms of damages.
Mel B's breakups tend to be a little high profile. Wasn't she dating Eddie Murphy at one time?
She was. I think she had Eddie Murphy's baby.
She did.
If I'm not mistaken.
Chris and I are like looking at each other like, huh?
Well, actually, no. I follow this Mel B thing quite closely. I also have to admit I'm a huge Spice Girls fan. I was in college when they were huge.
Everybody experiments in college.
Yes,
right?
exactly. We were just debating what was the better Spice Girls song. Was it Do You Want to Be, If You Want to Be My Lover, which we played as the bumper music, or my favorite is I Saw the Sign. You may be familiar with this. Do we have that, Cal?
Maybe. If it would roll, I have the sign. Yeah.
It's a good one. It'll be worth the wait.
Ace of Base, right? Come on.
Let Cal, while Cal plays with it, keep
sorry.
going.
Oh,
yeah, well, anyway, the nanny was the nanny was asked to be deposed. And the nanny did not show up. And she was just totally gone, saying, I'm not well, I can't be deposed. So right now, pretty much everybody's waiting for that deposition.
What's the age difference between the husband and the nanny? Do you have any idea? I mean,
25-year-old nanny And the husband, I think he's in his early 40s.
45 is 3
There
minutes.
you
Yeah.
go. There you go.
Yeah.
Age is just a number. By the way,
42. He's 42.
I'm going to throw a flag and call foul on Chris's allegation that he was a big Spice Girls fan, as I saw the sign was an Ace of Base song, not Spice Girls.
And I don't know the difference between Elvis and Meatloaf, and I've blown this one too. Every hour I have to make a mistake about a music issue. Terrible. What a day.
Anybody else need a job? We've got another seat over here.
So the nanny has claimed, this is what she's claimed. She's claimed that both Belafonte and Mel B enticed her with alcohol and got her to participate in a threesome. And she says she has never slept with Belafonte without Mel B being personally present and or participating.
And she also slept with all of the members of Ace of Base. Just to tie it in. That's why we're playing the Ace of Base song now.
And was paid in Bitcoin.
Yes.
Just want to make sure.
Yes.
Disclaimer, joke.
Just disclaimer, there will be no law in this hour of Law Talk.
That's exactly right. We're talking a little bit. No, actually, we're talking about divorce issues that Denise deals with us all the time. That's the majority of cases in the state of California, or almost all states, is divorce law.
So let me ask this question, Denise. In how many cases, divorce cases, does one spouse allege against the other that they were doing things with community assets that they shouldn't have been doing? Is that a common issue to bring up?
That's very common. A lot of people prepare for the separation date, and prepare meaning transfer funds or transfer assets or do things like that. That's very common in California. Other states, though, you have to realize there's many states where in order to get a divorce, you got to prove fault. So you can't get a divorce just automatically like you can in California.
That'd be easy for my wife.
The reason this case is so interesting is because the nanny has actually sued for defamation, invasion of privacy, intentional infliction of emotional distress, and she's asking for an unspecified amount of damages. So there is a suit that was joined and brought in to the divorce action, so basically consolidated.
Do we know which facts she's alleging were defamatory? Was it that she slept with Belafonte without her being there? Is it the allegation that she got the abortion? And maybe we'll have to catch that when we come back. But what specifically is she alleging?
Well, it's probably the abortion part of it that she's really upset about, because the allegation is that he paid for an abortion. So
we're going to continue with some other topics that are probably not legal in the next 15 minutes. So come on back, and who knows what we're talking about. I don't know. We got time.
This is RadioLawTalk.com.
I can picture you.
Those of you who are fans of Radio Law Talk know that we have talked about the Tiger Woods case in the past, and Todd has a quick update on the Tiger Woods case.
So Tiger Woods was set to be arraigned in July on his DUI, and that got continued to August. And there was speculation as to why. Well, the reason why is the type of DUI that Tiger Woods was arrested for was very difficult to prove. It's a narcotics-based DUI. I think they might have had issues proving intent, which is undoubtedly why Tiger Woods was given diversion. And what that means, and we don't see this too often in DUI cases, what that means is he was allowed to plead to a lesser offense of just reckless driving. And if he takes a class on driver safety and narcotics use in driving, at the end of a specified period of time, if he can come back and prove that he has taken that, he can then withdraw his guilty plea. When somebody pleads, there's two phases. You plead guilty, and then you are sentenced. Diversion is where the sentencing portion is diverted or delayed, and if you do what you're supposed to do in the interim, you never get sentenced, and you're allowed to withdraw your guilty plea, and everything goes away. That's why they call it diversion.
But Todd, what does that have to do with Bitcoin and Spice Girls?
Because they think he paid his bill in Bitcoin.
Okay, there you go.
Okay, so the nanny. Let's focus back on the nanny.
We are now going back to Mel B. Belafonte, who I believe is no relation to Harry Belafonte.
Or Ace of Base.
And let's reset this because I feel like we've been jumping around everywhere.
And Giles is the nanny.
What's her name?
Giles.
Giles.
Okay, so she apparently took tapes, videotapes, maybe audio tapes. We don't know exactly what the tapes consist of the sexual actions between her and Mel B and Stephen.
It was
Belafonte.
always three. She claimed it was always the three of them, not two of them together.
That's correct. And so she says she has them in a locker, and she threatened to release these tapes. And so this is why I think that this case is getting so drawn out and becoming very public. And Giles is not cooperating right now. She filed this suit, and now she seems to be stepping back and not wanting to cooperate.
So Denise, what are the elements of defamation? If somebody gets sued for defamation, what do they got to prove?
Well, defamation is kind of a catch-all term. It's for any statement that hurts someone's reputation. If it's written, it's defamation that is called libel, right? If it is spoken, then it is called slander. So it's basically something that hurts someone's reputation.
And
very broad.
And a defense to that would be it's something that is false that hurts their reputation, but if what was said was true, is truth a defense to defamation?
Absolutely.
So the issue that I see here that's interesting is if the nanny is alleging defamation based upon the fact that she engaged in intimate relations with Belafonte and that she got the abortion.
Well, back up. Not just Belafonte.
Belafonte and Mel B.
Right.
Okay. And if she is alleging defamation because that was disclosed, but now she's got tapes that actually prove that it happened.
Truth.
Isn't the truth the defense to what she's alleging?
Yes, I do think that Giles has admitted to that, so that's probably not what she's complaining of. I think she's complaining that her reputation has been injured by the alleged abortion that she had. And
so the defense to that would be if anybody is able to show proof that she indeed did have an abortion, and that came about and that Belafonte paid for it, then that might be a defense to that allegation, because as damaging as it is to her reputation, it was true.
Well, here's the other thing. And how much was paid?
It was almost £300,000,
which is about
$500,000, which is almost 130 Bitcoin.
Yeah.
I noticed that Cal has vacated the producer seat right now. We've referenced Bitcoin a little bit too much. It's interesting. We were talking earlier, or a couple of shows ago, about the student loan crisis and the mortgage crisis, and one of the pieces of advice or statements here was that if you file a deposition and they don't send anybody to the deposition, then things cut in your favor in terms of lawsuit because they refuse to go to the deposition. Didn't this just happen, something similar in the Mel B case where there was a deposition and Giles didn't show up?
She did not show up, and she claimed she was not well. Now, I don't know whether or not Mel B has gone and gotten an order for her to appear at the deposition, but that would be the next step, would be an order compelling her attendance at a deposition.
Well, here's an interesting fact about depositions and the setting of depositions, and a lot of us know sitting in this room what happens. They're canceled constantly or all the time. There's always one reason or another. If she doesn't show for a deposition one time because she doesn't feel good or having issues, no big deal. Second time, third time. I've had it where they've done it 2-3 times. Then you bring your motion to compel to get them to show up to the deposition. But the fact that she canceled once or twice is really not unusual. And a lot of times it's the attorney's conflict. Try to get. I bet there's a lot of lawyers. Try to get like 3 or 4 lawyers schedule, the defendant's schedule, and the plaintiff's schedule all together.
Yeah, but it sounds like this was one of those situations, and I'm sure you've all been through it. You show up for the deposition. You have your client there that just flew out from Chicago. The deposition's in San Francisco. You drove up from L.A., and the witness just doesn't show up. That's a big deal, and you can get the court to issue an order forcing the other side to pay you $10,000 because of all the money that you spent to show up when the witness wasn't polite enough to tell you in advance.
Very, very, very true.
Yep.
And there's another evidence issue here. There were 15 boxes of Spice Girl memorabilia and other tapes and other things that were removed from the home and put into a storage and then somehow removed from the storage and put into another storage in the name of Giles. And she's been asked to turn over the code so they can go get this stuff. So there's potentially community property or separate property, because Mel did Spice Girls before the marriage, but potentially there is evidence or property that has been placed to where they don't have access to it, except the only one is Giles. That's really interesting.
Well, you had mentioned something else that sort of caught my attention with regard to Giles' statement that I have these tapes, okay, and if you don't back off, if you don't do this, I'm going to release these tapes. And she's got to be careful there, because that comes dangerously close to extortion. Now, she has the, may or may not have, she has the right to, extortion is one of those interesting crimes in the sense that she has the right, and people have the right to say, you need to stop talking bad about me. And then assuming there's no other impediment, she has the right to release tapes. But she does not have the right under the law to condition the release or non-release of those tapes upon whether or not somebody is going to cooperate with her demand. And this is where she can get in trouble. This is where her attorney can get in trouble by a poorly written letter that conditions the two. I know that the ethics folks over at the state bar really look at this issue closely, and it could be an extortive issue if she is threatening to disclose personal information that's damaging in exchange for a demand that she's making, and that's a felony.
That is such a good point. And there are so many lawyers out there that threaten things that they shouldn't be threatening. The most common one is criminal prosecution. If you don't do what my client has asked and pay $100,000 by next Wednesday, we will report you to the police. That is illegal, it's unethical, and it can't be done.
That's right, and you have to remember that you can't threaten criminal action in a civil case, and divorce is a civil case. So that is one point, and that's a very interesting, phenomena, I guess, that's happening here. But what's really at heart is the nanny now. It looks like she doesn't really want to cooperate. She doesn't really want to give up the items. She doesn't really want to be deposed. She's very much claiming she's under extreme emotional distress because of this suit. That she has been, she was a hardworking girl. She's actually from Germany. That she was brought here and seduced is what her position is.
Well, that is almost the end of hour 2. We're going to talk more in hour 3 about Madonna and a really interesting case, the Jason Corbett murder trial in North Carolina. We'll see you in hour 3 right after the break.
To Mark. The following is a live copyrighted presentation. Ladies and gentlemen, it's time now for RadioLawTalk.com with your host, Frederick Penny, attorney at law. And now, RadioLawTalk.com.
Welcome to RadioLawTalk.com. I'm your host, Frederick Penny. Welcome those of you live from K-High, 9:50 a.m. out of Auburn. Rolling in on our third hour live. You can listen to us the first 2 hours where we talked about Taylor Swift and Bitcom. Do not listen to the Bitcom part. Bitcoin. That's right. If you want to save Cal's life. But welcome, K-High. Thank you to Crack, 1370 AM in Reading and Red Bluff. We love being on Crack Radio on Red Bluff and Reading. All 3 hours live, and we've got some exciting things coming down the pike, some other cities that are picking us up very soon. So we are expanding Radio Law Talk quickly. Thank you, SRN Radio. SRN, we are on satellite on SRN. And you can tweet us at Radio Law Talk, or Denise.
Or call us at 855-LAW-RADIO.
And that is
We'd love to hear from you.
Yeah, that's my co-host to my right, Denise Dirks, who is a family law lawyer, and to my left, Todd Cunin, a former prosecutor for the District Attorney's Office, and another co-host, and now he has his own criminal law practice. And then top left over here is Chris Rodriguez, my very good friend that we've known. We love basketball, by the way, together. He is a employment lawyer, corporate lawyer, and business lawyer, and
Civil litigation.
Civil litigation. He does quite a few interesting cases that he has taken care of. A couple interesting things we want to talk about this hour. Two very interesting things. First of all, this case out of North Carolina is just intriguing. And it was one that we really didn't tweet out early on, but the verdict just came down. It's the Jason Corbett murder trial out of North Carolina that we're going to talk in detail about. You got to wait and hear about this, because this is one of the most bizarre cases. It is about a daughter and a father who allegedly murdered the daughter's husband, and the father is a 31-year veteran of the FBI. And what happens in this case, we're going to go through the details and talk about the law and how it applies. But I think more important than that is to talk about Madonna. We're going to talk about Madonna's issue with her friend Darlene Lutz.
If you have to choose between Madonna and murder, go with Madonna.
Go with Madonna. I think Madonna is interesting. And this is something that is one of the most interesting things that I've studied and read, is about her personal items. So Madonna had this friend by the name of Darlene Lutz that was a good friend for over 20 years, that hung out with her, lived at her home, hung out at her home. They did all kinds of things.
Translation, sponged off her.
Can be, I would say, possibly sponged off her. And
Madonna's Kato Kalin.
Yes.
That's exactly right. That's exactly right. So anyway, what happens is all of a sudden some stuff disappears. And they kind of break it off, and they're not such good friends. And this Darlene Lutz takes some stuff out of her home, supposedly, or gets a hold of some stuff, including her satin panties. And Rodriguez just woke up. And Tupac, who's Tupac? He's the famous rapper, right? That got killed at age 25, that was murdered, and a famous love letter between Tupac and Madonna that she had in her possession. So the big issue is there's this falling out, and she's helping her move out. That is, Darlene Lutz is helping Madonna move out of her house, and these things all of a sudden just pop up and appear where?
eBay?
In an auction. In an auction. So the big issue is whether or not Madonna can stop her from auctioning off these private items of hers, especially her satin panties. And here's the issue. The issue is, what Madonna's saying is that she stole her personal stuff that contains her DNA. And part of it also was a brush of Madonna's. And that is her private information that's going out that she's selling. Lutz says if it was so personal, apparently she mailed it somehow, maybe to Tupac or something. Why are you mailing out this private stuff?
Okay, can I ask a question?
Sure.
Did she steal these items from Madonna, or was she given these items?
Go ahead,
Yeah.
Denise.
There's 122 or 128 items. Some of them were given to her by Madonna, and Madonna doesn't care about those because she legitimately gave those items to him. But there are these others, I think it's like 6 or 10 different things that she did not give to Lutz, and somehow Lutz got them, and she was going to auction them off at Gotta Have It Collectibles.
For $100,000 is what the auction price was. So Madonna took them to court to get an injunction to stop them from doing what?
From selling the 22 personal items.
That's exactly right.
And was the injunction granted? I'm assuming it was.
It was.
It was. So, and this was a number of months ago. So basically the judge came down and said, look, this is really private stuff, and there's no evidence that it is yours. You could have taken it, but it kind of comes down to a privacy issue, and then her DNA was on it. And for now, that doesn't mean that it's for good. They can't try to sell it, but for now, there's basically it's like a TRO, temporary restraining order. They basically stopped her at this point from selling it, and we don't know what's happened from that from that point on, this was about a couple months ago that this happened?
Yeah, this was a preliminary injunction
Right,
only, so
right.
it's not the final end-all, be-all order.
Yeah.
So just a note. I know that if you have anything that you need to do here at Radio Law Talk, we say get your personal attorney. We're talking general legal principles. But if I was to give advice to folks, I would say do it the way Madonna did it. Get your injunction. Don't do it the way O.J. Simpson did it, which is to hire two thugs and go and kidnap somebody in a hotel room, because Madonna is not going to be in jail for up to 9 years, maybe even longer, trying to get parole, going about it the way she did it. O.J. Simpson, on the other hand, not so tactful.
That's exactly right. But the thing is Madonna did it the proper way. Some interesting little points is Miss Lutz argued the statute of limitations. Chris, most people know what the statute of limitations is. What does that mean, statute of limitations?
So the statute of limitations, for example, so I'm assuming that what she argued was that Lutz had stolen her silk panties, because that's what we're all focusing on, is the silk panties. So let's just talk about it. Yep.
Took them.
So she took them. Okay, it's under the law that's called conversion. And I'm sure what Lutz is saying is, I stole these panties. If I stole them 2 decades ago. So if she wanted to come after me for that, she had to do that 15 years ago. And so the fact that the limitations period has run, she has no recourse against me for stealing or converting these silk panties, so I should be able to auction them off.
And in addition to that, she's claiming that Madonna and her had a falling out in 2004, and that they had a legal settlement that should have also resolved Madonna's claims against her.
Yeah, some other things. There was photos in that little
22 item.
Yeah, 22 item thing. Photos, a checkbook, a used hairbrush, cassette tapes. Maybe the cassette tapes are also part of the Spice Girls cassette tapes.
Yeah, could be.
And other unreleased recordings. Now that would be interesting to see what's on those unreleased recordings.
And in addition, Tupac Shakur, is that his name?
Yeah.
He sent a love letter, and that probably is one of the most valuable of all the items. And he explained to Madonna in this love letter why he had to break up with her, because they were different races, and because he had street cred, and he would be the one that would suffer from being with Madonna.
And then 1 year later, he was murdered.
That's right.
So that's why the value is in that letter and those panties. And that's what's important, is the silk panties value.
This is a really interesting case, and I think we're speculating a little bit. But if the thing that you said about Madonna having a settlement agreement with Lutz, assume that there's some language in there that says, we're going to walk away from each other. You get to keep everything that you have of mine, and we're going to go our separate ways. And now to try and come back and maybe undo that.
We'll see what happens. We'll be right back.
You are listening to RadioLawTalk.com.
I know you don't know what I'm going.
Remember, we're talking about general law practice issues, and if you have a problem that you need to deal with an attorney, go get an attorney and don't listen to us all the time, because we're just talking about general practice issues. That's a disclaimer we throw out there every single hour. But Chris, what's your favorite Madonna song?
Favorite Madonna song? God, you're putting me on the spot here. Maybe Girls Just Want to Have Fun, I think.
Oh, Chris.
Great, Chris picks a favorite Madonna song from the Cyndi Lauper anthology.
Is that not Madonna?
That is
Cyndi Lauper.
I am having a rough day here.
You have no musical identification at all.
I love
No
music,
skills.
but apparently I can't match up artists with their songs.
Chris is waiting for the Meatloaf, Elvis, Madonna trio to come out, along with Mel B.
And Ace of Base.
And Ace of Base, the quintet.
The listeners that is joining us live, Chris, the past 2 hours, has missed on every single song. Hey, what's that? That's a great Meatloaf song. That's Elvis. Oh. So, Chris,
I thought that I Saw the Sign by Ace of Base was a Spice Girls song.
You know,
Great song, though.
Well, it was spicy. It was the less known spice, cumin spice.
Yes.
Yes.
we do talk
The
about the law
Indian
here.
basil. The Indian
The
basil.
Indian basil spice.
I just made that up. That's probably wrong, too.
We do talk about the law here every once in a while. So.
On occasion.
So those of you who don't know, Chris Rodriguez over here, he's our Harvard boy. We call him the Harvard boy. About 5 weeks ago, he got mad that we're calling him a Harvard boy, so we call him now Prince Harvard.
My agent said, hey, you can't let this continue.
We're Prince Harvard now because he's a Harvard boy. So, and that's how smart he is. So that's why he's going to tell us a lot about Jason Corbett murder trial that he doesn't know about. It's Todd and I and Denise that know more about it.
I just liked seeing the look of all the color drain out of his
Isn't that
face
great?
when you looked at him and said, he's going to go over Jason Corbett. He's like, Corbett, what is it?
What is he saying?
He's ready. He's ready to deal with Madonna.
The champagne's not Corbett. That's Corbell. Okay, yeah.
That's exactly right. But you got to hear about this. In North Carolina, Jason Corbett, okay, he is a man from Ireland, and he needs a nanny, and he puts an ad out, and a gal from, I think she's from Texas or North Carolina. I can't remember where she's from, but she answers the ad, and that's his wife, back up, answers the ad because his wife passed away, the guy in Ireland, and he has 2 children, and she rolls back there, and literally within a few days, they're lovers. And it doesn't last long. He's like 40 and she's in her 20s. There's an age difference. And they end up coming back to America. They settle down in North Carolina, and her dad, Molly Martins Corbett, her dad is a 31-year veteran of the FBI.
Okay, can I just make sure I have all of this straight?
Sure.
Corbett, older Irish man,
Right.
gets nanny from North Carolina in her 20s.
It's from United States. They moved to North Carolina.
An
I
au
can't remember.
pair.
Okay.
Au pair.
Right.
She went
Au
to
pair,
act as
yep.
an au pair.
Yep,
Thank
okay,
you.
Okay, so she goes to Ireland. They hook up immediately, and they come back to the United States.
Yes, but his wife, this man's wife, Corbett's wife, his first wife, passed away somehow. Passed away. So he's got 2 children, young children. So they move back, and now she's the stepmom and the wife of Jason Corbett. Got it?
Yep, I'm with you.
So there we are. So we're back in North Carolina. He does well. They live in a beautiful home. Molly Martin's dad is a 31-year veteran and retired from the FBI. There's some issues going on with this marriage.
Yeah, his name is Thomas Martins.
That's right, Martins.
The retired FBI agent Thomas Martins.
Right.
Okay.
There's some issues going on with this marriage. Apparently, Jason is very abusive. Both, he yells at her, and the child there's actually video, Denise, of this child talking to a social worker, one of these 2 children, saying that the dad hits the mom, physically hits him at least on 2 occasions. So, and that didn't come up in the trial, and that's going to be another issue we're going to discuss in a minute. So what happens is dad comes over to visit with mom, and they're staying in the basement, and they get in an argument, the Molly and Jason upstairs. It's in the middle of the night, and there's details we'll talk about later about why they got in the argument. Dad comes up to see what's going on, and this is what is alleged. He's got a stranglehold around Molly, and the dad has a bat that he bought for his grandson that he brought with him. And he decides to use it on the son-in-law, Jason, to stop him from choking. And he claims that he was saying, I'm not only going to choke, I'm going to kill her. And so he starts beating him with a bat, and then to stop him. And the issue is, and he eventually falls, dies, and then he's hit with a brick supposedly by Molly, and he dies. And so there's a murder trial of Molly and her dad of Jason Corbett, and that's what this whole murder trial is about. So the murder trial occurs. Long story short, they're found guilty of 2nd-degree murder and sentenced to 20 and 25 years. This gal and her father. Interesting issues here. A lot of interesting issues. What are some of the issues?
Todd, what's the difference between 1st-degree murder and 2nd-degree murder?
In the state of North Carolina, First-degree murder is intentional killing with malice and premeditation, so something that's really planned out. Second-degree murder is intentional killing with malice, but without premeditation. So that would be the heat of passion, spur of the moment things, and this fits that definition according to the facts that we have heard, where there's an argument, dad comes up, clearly there's no premeditation when he walks in and sees his daughter being strangled, gets the baseball bat, hits. They're saying
no, he's got the baseball bat with him.
He brings it up. With
okay,
him.
Because he hears the.
Still, he hears all this. He goes in. I guess you could make the argument that there was some premeditation. Interesting thing about premeditation: there's no time limit. You can premeditatedly kill somebody in 10 to 15 seconds if you want technically, but they are going under the non-premeditation aspect here and saying that the manner in which he effected self-defense was a little overboard, and we can continue that and talk a little bit more when we come back from the break. Fred, like you said, interesting case. We're going to be back on RadioLawTalk.com in just a few minutes after these messages to continue the North Carolina Corbett murder case.
You have found RadioLawTalk.com.
We're still talking about the Jason Corbett murder trial. Let's make something very clear. During the break, we were discussing Thomas and Molly Martins.
Corbett.
No, I'm talking Molly and Thomas. The dad.
Thomas.
The dad.
That's right.
So let's make this clear. They did not testify at the trial. What happened is after they were convicted, they got on 2020 and were interviewed and laid it out. And so a lot of this information, I believe it was 2020. I want to make sure that but anyway, a news program and laid out their side of the story after the fact. And obviously it's up on appeal. But all the stuff we're talking about, what happened on their side of the story, a lot of the stuff they're already talking about.
This is interesting that you say that, and we didn't talk about this at the break, so I may be going in a slightly different direction, but I'll put Todd on the spot. I know that you...
This is payback for the Cyndi Lauper stuff,
exactly.
isn't it? Okay.
Exactly. It's well known a defendant is not required to testify, right?
Yes.
But in a situation like this, it almost seems like there needs to be that side of the story put out there. Otherwise, you just have a dead guy, and there were only three other adults in the house. So doesn't somebody, if you're the defense lawyer, have to stand up and say, this was self-defense, and here's why?
Hold on one thing, Todd. I think what's important that question that needs to be brought up to Todd also, because he's the criminal law person here. Denise, remember what evidence did not come in was one of the children went and talked to a social worker and said, my dad is yelling at, and has beat my mom twice. Go ahead, Todd.
So to answer your question, all right. Admittedly, the two defendants did not testify in the sense that they did not sit in a witness stand and give evidentiary testimony to the jury. That does not mean that their explanations didn't come in. And the way it comes in, we all know hearsay is inadmissible in court, right? However, there's an exception to that called the admission of the party opponent. And if either the dad or the daughter spoke with law enforcement, okay, and during that testimony or during that interview with law enforcement that's often recorded, if they laid out everything that happened, all right, then the ability for the prosecution to introduce that as evidence of what they say gets that statement before the jury that, okay, this is what they're saying happened. Now, and it's admitted under the idea of an admission of a party opponent. They are opposing the prosecution, and because they're opposing the prosecution, any statements they made beforehand may come in. Now, the question here would be, why would the prosecution admit statements of the defendant that are, quote, self-serving to explain this whole self-defense scenario? Well, maybe there was something in the statement that actually helps the prosecution. For example, the dad going up and saying, well, this is what happened. I saw him there, and I saw him with my daughter in a headlock, and I brought the baseball bat. That's all stuff prosecution wants to get in, because they go ahead and bring it up. And they have to get all of these things when they get this statement in, but there's a rule called the rule of completeness, which means if there's a part of an interview, let's say she gives a 5-minute interview to the cops, and the DA is interested in the first 2 minutes of that interview because that really helps the prosecution. The rule of completeness that the defense can say is, you can't just play 2 minutes. You got to play the complete interview so the jury gets the context. My guess is with this that by the end of the trial, anything that the defendants could have testified to on the stand had already been admitted by way of testimony from officers or recordings, such that their attorney said, we didn't need to put them up there and subject them to cross-examination. They just get toasted.
Yeah. The thing that I was thinking about that was really critical is the length of time that it took the two defendants to call 911. And I think that that was really a very critical piece that was admitted to by the defendants, that they didn't immediately call 911 once the guy was down.
Yeah, trying to say that they kind of concocted a story together, and that's what the inference was.
Yes.
Chris, you had a what?
Well, I mean, I wanted to get back to this kind of case strategy point when obviously the prosecution goes first. And so the first party that gets to decide what evidence comes in is the prosecution. The defense can't do anything until it's their time to put on their case. I mean, they can cross-examine the prosecution's witnesses and so forth, but they can't put any evidence of their own on until it's their time to start the case. So have you ever seen cases where the prosecution will put on this type of evidence that maybe it doesn't necessarily advance their case, and it's actually putting in theories that the defense will raise, but they want to cut the defense's ability to basically put in very polished testimony and things like that. I mean, obviously, when these defendants were being questioned by the police, they weren't prepared for that questioning. They didn't have a lawyer working with them in a conference room for days and days before they got on the stand. So is it ever a strategy decision to say, we're going to play these statements that where the defendant is going to try and explain what they were doing and why they did it, to get that story out there first before the really polished and rehearsed version can come on as part of the defense case?
The short answer is absolutely. And I'll tell you why. My personal philosophy on whether it's as a defense attorney or when I was a prosecutor is there are two types of facts. There are facts that are good for me, and there are facts beyond change. I don't like using the term bad facts, because when I use the term bad facts, I start to really get into this mindset of, oh, I got a bad case, I got this. So just philosophically, I like facts that are good for me, and there are facts beyond change. If I have facts that are beyond change that I know the other side is going to present, I would much rather be the one that finds a way to present it so that I get the first crack at not only presenting it, but I also can explain it or introduce something that contradicts it immediately. If I wait for the defense to bring it out, now, as a prosecutor, I got to wait till they're done with their whole case before I can start my rebuttal case. And who knows how long that's going to marinate in the minds of the jury. I'd rather get it out there and get it done. We see this also with the defense. When let's say a defendant's got a criminal history and they take the stand, and I know that the prosecution's going to come back after he's done and say, hey, Mr. Jones, isn't it true that you've been convicted of arson and rape and all of this kind of stuff? Yep. I would rather, as the defense attorney, if I have to call my client, have him testify and be the one that says, now, you don't come here with a crystal clear and spotless record, do you? No, you have actually been convicted of this. I'd rather be the one that tells it to the jury because it makes it look like I'm not hiding anything. So, yeah, you do see that.
So here's another important question on this same thing. Here's another fact that came out from the side of Molly and Thomas, the ones that were convicted. Thomas said that he talked to the wife's father, the former wife that passed away at a young age in Ireland of, quote, a heart attack. And he talked to that father, and that father said the following: according to Thomas, I think he killed my daughter. Now, does that evidence come in or is it inadmissible, or is it hearsay? Now, the guy from Ireland, they said, recanted that. I'm sorry.
Question. When I think it's important to know when that statement from the father of the first wife in Ireland was made, because I think if it was made before the murder, then that could be relevant to the state of mind as he's hearing this argument, saying, "Oh, maybe my daughter's going to be next." So I would think that it'd be relevant if it was made beforehand.
It was supposedly.
I would say, if I put on my judge hat, I would be surprised if that statement ever made it into evidence for this reason. I do agree with you, Chris, that even though if they knew it beforehand, it might be relevant to explain the reactions. However, you need to understand that in California, for example, Evidence Code Section 352 defines relevant evidence, or the admission is as long as its probative value is not substantially outweighed by the prejudice that it might. So what's a probative? It's probative to explain the reaction. What's the prejudice of that statement? That the jury might hear this uncorroborated evidence that the decedent may have killed somebody else, to the extent that the jury would disregard if I was a judge, I would say it's highly likely that the jury will disregard anything that might be probative and actually hold it against the deceased for the unduly prejudicial or substantially prejudicial aspect. I'd be surprised if that evidence ever made it in.
Yeah, here's some important things to remember. Number one, if you have a question, why don't you call in at 855 Law Radio about this case? But we want to talk about the jurors that were interviewed afterwards and what they said and the issues about whether or not there was some improper things said or done by the jury. And we'll talk about that right after the break. You're with Radio Law Talk. I'm your host, Frederick Penny.
Todd, great job. I would have overruled my own objection at that point. I agree with you.
We built this city on rock and...
In case anybody's wondering, this is Meatloaf on RadioLawTalk.com. We thank you for listening.
And I would do anything for love.
I love Elvis.
I love that song, too. Chris, there's your Meatloaf for you. Hey, we're talking about the Jason Corbett murder trial. Now, we're going to get into an important part is the jurors who were interviewed and whether or not there was juror misconduct. Here's some interesting things that the jurors said. They said they watched Molly's reaction. Now, don't forget, Molly did not get on the stand, but they watched her reaction to everything, it sounds like, that occurred during the trial to see how she reacted. Not only do they watch it, but then they wrote it down. And that's almost like they're going out and doing their own investigation. Then they followed up and said the reason they found second-degree murder is because of one simple thing. It sounds like they were okay with him, that is the father, and Molly defending themselves, but they went too far. That they believe that when he was down, they kept beating on him and killed him kind of after the fact, that they could have made sure that he was just down for now and then got out. The other issue is, and Todd was bringing this up and we're talking about it in the break, is they don't, you can't be stale in a trial. You got to understand emotions. When you're defending yourself, and I'm not jumping on their side because there's two sides of the story here. There's a reason why there's the thing called adrenaline going. And to say stop, and the father saying he was worried about him getting back up. Don't forget, Jason Corbett, 6'3", 250 approximately. That's a big boy. And so dad is not a very big guy, and wife is not very big. And so the issue is that juror misconduct for them watching what she's doing and making comments about it and writing it down and not necessarily listening to, probably listening to what the rest of the evidence is, but focusing on that.
Well, let me comment on that here. I realize that this was a North Carolina case, but jury instructions, with some differences, are pretty uniform state to state. And in California, we have CalCrim, which is the California Criminal Jury Instructions, number 22 under evidence. All right, and it says this. This is what the judge reads to the jury.
And this is California law.
This is California law, but I would imagine North Carolina is very similar. This is a uniform principle about evidence. You must decide what the facts are in this case, and you must use only the evidence that was presented in the courtroom. Evidence is defined as the sworn testimony of witnesses, exhibits admitted into any evidence, and anything else I, the judge, told you to consider as evidence. So there it is. Sworn testimony of a witness, exhibits, or something that the court has told you that you should consider as evidence. And that brings up this idea, is the reaction of a person who does not testify, i.e. the defendant, does that fit into any one of those three categories? She's not a sworn witness. She's not an exhibit. And the judge certainly didn't direct the jury to consider the reactions of that individual. And so by the jurors saying, well, we watched her reactions, we watched the way that she did, and then making a determination that we didn't think that she was bipolar or whatever, well, that's not one of those three things. And there's another instruction that says to the jurors, do not do any research on your own, do not use a dictionary, other reference material, investigate the facts or the law, or conduct any experiments. So if I'm a defense attorney challenging this on appeal, I say, well, they considered things that weren't evidence, and oh, by the way, by doing this ad hoc view of the defendant to see how she responds and then make determinations of her mental status based upon how she responds to stuff, that's a juror conducting an investigation or an experiment in the courtroom. Chris.
Let me argue the other side of it, because anybody who's ever tried a case, and I'm sure everybody sitting here has told your client, when you hear something you don't like, keep a straight face, be professional, don't lose your cool, because the jury is watching you. Everybody knows that the jury is watching you as the lawyer. The jury is watching your client, not only while trial is going on and testimony is being elicited, but also when you're coming back from lunch, when you're seeing the jurors in the bathroom. Everybody knows that you're being judged at all times, which is why doing a jury trial is so difficult. You have to be on all the time. And so to quibble with your point, if you could interview the jury afterward and say, well, did you look at my client while so-and-so was testifying and judge his reactions, they're all going to say yes if they're being truthful. What then do you have to do? Do you have to put up a black curtain around counsel table so that nobody can look there? I would say no.
No, I think because the statements were let in by the prosecution that the defendants, in essence, did testify, if you will, and that it is the jurors' purview to do the fact-finding, actually make decisions as to what's fact and not, and that goes to credibility of the witnesses. So they have to determine whether or not that witness was credible, and watching a defendant may be part of that.
Now there's reality. There's the law and there's reality. This is kind of a game. I remember my first trial, well, that was a second or third one, that I was in a small county, really tiny town, trying a case, and I pulled up in my BMW, my new BMW. Wrong. Parked in the same place where the jury's parked. Bad idea. I've talked to my clients. During the break is sometimes the worst time. You've got to be careful of what your client's doing, how they're looking. It's not that you're even faking anything. It's just the jury's going to watch everything they do. I know this famous story of a courthouse, and I've been in this courthouse and tried cases in this one courthouse, where you walk down to where they eat and where all the restaurants are. It's down the hill. And this was a plaintiff's lawyer that was injured in an accident and had no problems walking down the hill, eating and coming up. And guess who else was walking down the hill coming up? Jurors. So how do you get around that? The reality is the jury watches everything, even when you're not in the jury box or not in the courtroom.
They do. They watch everything. To get to your point, Chris, I think that you have jurors that watch a lot of things, and it's difficult often for whoever is on the losing end of the trial to pinpoint whether or not the juror did something improper that led to the verdict not going your way. And that's because you don't really have an opportunity to interview jurors after the fact. I mean, there's the opportunity, but in every criminal case I've done, the judge always says, if anybody wants to stick around, talk to the attorneys afterwards, go ahead and do so. And every once in a while I get people that'll stick around and talk, but most of the time they all take off. This is an anomaly. You don't have 20/20 typically interviewing jurors after a case. And if you have a juror that goes on to 20/20 and admits to something, now it's no longer speculation that the juror may or may not have been influenced by something that didn't come from the witness stand. They've confirmed it by the interview. And getting to your point, Denise, about the witnesses or the defendants did testify through statements that might have come in. The question I would have is, are the reactions that they were looking at reactions that were made during their testimony that was played, or were they reactions to something that might have come afterwards, like pictures or something somebody else said? Because if their reactions weren't directly related to something that they testified to, I go back to the CalCrim 223 that talks about witnesses, and the judge says that the jurors are alone are the credibility and believability of witnesses, and they can say, they can view what was the witness's behavior while testifying. And so if it's something that the witness, a behavior that they observed while the witnesses were not testifying, or statements that are attributable to that person, the argument would be that it doesn't come in.
It was during, by the way, the evidence was, what they said was during the time that she looked at pictures, when there was a flash, a picture of the children, and there was a picture of him being beaten in his skull. It's her reaction at that time, and they literally wrote it down. They didn't just think it mentally, they wrote it down as like evidence that's being presented. But that's the interesting thing about it.
It's wild stuff, but this idea that they went too far, and that gets to the staleness of the courtroom. A lot of times, jurors want a Monday morning quarterback what somebody should have done, and it's easy to forget the adrenaline and everything that's going on.
20 to 25 years, and they're going to appeal it, I'm sure. Let me tell you guys, Todd and Chris and Denise, it's time to put the deodorant on. We've been through 3 hours. We're rocking and rolling. We're ending this show. I want to do a couple of quick shout-outs and thanks. Again, thank you to Thomas Jefferson School of Law and Michael Shear. Thank you, Cal, back there. And next week, I believe we're going to have some Pepperdine students doing some research for us.
And thank you, Michael, for stepping in for Seth.
And I want to thank Todd, because that was really interesting, the criminal law thing. I heard the phrase, you make me want to be a better man. Todd made me want to be a criminal lawyer today.
Talk to you later.
That's right.
See you next week.